Leroya M. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. I'm assuming that counsel will have read all the directions concerning virtual conferencing, virtual hearings. And with that, appellant, if you are ready to proceed, if you'll identify yourself for the record and let me know how much time you wish to reserve for rebuttal.
Good morning, Your Honors. Naomi Fetterman, on behalf of the defendant appellant, Ms. Leroya M. I'd like to reserve 10 minutes for rebuttal, please.
10 minutes, thank you. Senior Associate Justice McDonald will be our timekeeper. He will let you know when there are 5 minutes, 3 minutes, and your time is up on your main argument, whenever you're ready.
Thank you, Your Honor. So the sole issue raised in this appeal is whether any rational finder of fact could have rejected the defendant's affirmative defense that she lacked the capacity to both appreciate the wrongfulness of her conduct and or to conform her behavior in accordance with our criminal laws. Now, I'd like to begin actually with the discussion of the standard for review because it's apparent that the state and the defendant have such a divergent approach to this court's role in reviewing the lower court's decision. Now, as we've argued in our main brief and reply brief, when we look at a trial court's decision regarding an affirmative defense, the standard has to be whether any reasonable, rational fact finder could have concluded in the manner that this court did. Now, the state responds with a sufficiency of the evidence framework, that is, construing the evidence in the light most favorable to sustaining the verdict. And as we've argued in the reply brief, that's simply an untenable approach to any assertion of an affirmative defense. At risk of being patronizing to the court, an affirmative defense, of course, concedes the guilt and then seeks to mitigate or refute it. So if the defendant is already placed in a position where they're conceding that the state has met all the elements of the offense, then it simply cannot be that the reviewing court assesses the evidence in the light most favorable to sustaining the trial court's finding of guilt on those offenses. Instead, what we see throughout case law is a review of the evidence below, and if it is reasonable and rational for the finder of fact to have reached the conclusions of law that it did. And then another important point that I'd like to start at is the role of expert testimony. Of course, the defendant presented Dr. Amble as an expert in conjunction with the testimony of Dr. Carvalho, who was the treating psychiatrist while the defendant was incarcerated at York. Yes, Your Honor.
This is a question from Justice Keller.
Oh, thank you.
I know it's sometimes hard to remember to look. Thank you, Chief Justice. Attorney Fetterman, good morning.
Good morning, Your Honor.
I'm having a hard time seeing, based on my review of an over 30-page memorandum of decision by this 3-judge panel, that they didn't have a rational basis for determining that the defendant had failed to prove her special defense. They focused a lot on the lack of substantial proof of an incapacity and substantial proof of the ability to conform her conduct to legal norms. Doesn't this also just basically, boil down to that they could have credited the state's witness and the other lay witnesses who talked about her behavior just prior to the unfortunate incident and rejected the testimony of the defense psychiatrist?
Yes, I believe Your Honor's question goes to the crux of what we've identified as the error in the trial court's decision. And so I don't misquote the standard that we see in Wysomerinsky v. Securis, which I think can most easily be found on page 5 of the reply brief. We recognize that it is the quintessential function of the fact finder to reject or accept certain evidence and to believe or disbelieve any expert testimony. The trier may accept or reject in whole or in part the testimony of an expert offered by one party or the other. The trier may not, however, arbitrarily disregard, disbelieve, or reject an expert's testimony in the first instance. There are times that the fact finder, despite his superior vantage point, has erred in his assessment of the testimony. Where the trial court rejects the testimony of a plaintiff's expert, there must be some basis in the record to support the conclusion that the evidence of the expert witness is unworthy of belief. So while I recognize the state has a differing opinion about whether this standard is applicable, as Your Honor pointed out, certainly, is it within the province of the finder of fact to credit expert witness testimony? Of course, but what we see is this court saying you have to reconcile that with a reasonable interpretation of the evidence below. And as we've pointed out in our brief, the reasons that the trial court articulated for rejecting the testimony of Dr. Amble are not supported by the record and are in fact refuted not only by Dr. Amble's testimony, but by the corroborative evidence presented by other witnesses, specifically Dr. Carvalho, specifically the recitation of Dr. Milestein's assessment of the defendant during her time at the Yale Psychiatric Institute. And that is ultimately the flaw of the trial court's decision. And indeed, it's most simply encapsulated in what the trial court identifies as the vulnerabilities of Dr. Amble's testimony. The reasons that caused it to reject Dr. Amble's testimony are equally present, if not amplified, in the testimony of Dr. Lewis. Justice Khan, I see you have a raised hand.
Thank you.
Yes, I do, Chief. May I proceed with the question?
Yes, you may.
Thank you. Have you answered Justice Keller's question, counsel? I wouldn't want to cut her off.
I appreciate that opportunity very much, as my concern was not ignoring you. But I did want to say that this is not simply a superficial assessment. What we pointed out in our brief is that Dr. Lewis interviewed fewer independent sources than Dr. Amble, met with the defendant for a far less extensive period for interviews, and did not have anywhere near the breadth of observation that Dr. Carvalho had in her assessment of Leroya M, which took place for over a year while the defendant was incarcerated. And if there are, Justice Keller, if there are any further points that Your Honor had wished that I make, I'm glad to amplify on that now.
No, I might ask a question later, but thank you. I'll defer to Justice Khan and let her ask her question. Thank you.
Thank you.
Thank you, Justice Keller, and thank you, Chief Counsel. Typically, we raise our hands to get ourselves in the queue, and I notice, for example, Justice Doria has also raised his hand, and the Chief will recognize us as we raise our hands. So I appreciate you looking at the screen, though. It's always very helpful when counsel do that. I have two questions around sort of similarly this issue. Didn't our jurisprudence, our past jurisprudence, particularly Medina, Perez, the Steiger case, don't they actually direct our result in this case in terms of the notion that even if, in this case, I think it's very different, right? The state brought in its own expert, but even in a situation where only the defense brings in an expert, the panel, whether it's a jury or a three-judge panel, they're not obligated to accept wholesale what the expert says. In other words, it's never been the law that jurors have to accept conclusions and opinions of experts. Experts are designed to guide them in their assessment of the evidence, but not to substitute their opinion for that of the jurors. And don't the Medina, Perez, and Steiger case actually, our precedent says precisely that?
Well, I would not certainly argue with the overarching idea, as Justice Keller raised, that the finder of fact is free to accept and reject expert testimony, lay testimony, and that's certainly within the province. But what we see, the language from the Supreme Court, is you still have to reconcile that with the evidence that's presented below. And if this case, for example, were tried to a jury, then the defendant's recourse would be a motion for judgment for acquittal, not motion for judgment notwithstanding the verdict. And we'd have the court still taking a review of the evidence that's presented below, and does it support the jury's verdict. In this case, because it was tried to a panel, we have this court obviously sitting in a position to review whether the panel's finding is supported reasonably by the evidence below. And
okay, so I understand what you're saying on that, and let me just follow up with this question. In this case, though, we had two experts, the state's expert and the defense expert. And if we were to agree with you, your position is they should have accepted Dr. Amble's conclusion and testimony. But in doing so, the panel would have had to reject Dr. Lewis's testimony, which was the opposite conclusion, correct?
I would agree that it would be difficult to accept both of their conclusions as simultaneously true.
And I noticed in your brief you focus a lot on the statement in the note left that the defendant wrote that said she didn't want a service because she didn't deserve a service. She was should go to hell or burn in hell or something like that. But it seems to me that in this case, the trial court focused on other things, like their position that the defendant was lying about the precise method in which the children died, not the content of the note beyond that statement, the organization in the note, the leaving the credit cards and the credit card numbers, and the sort of anger statements towards her ex-boyfriend and the father of the children, her ex-husband, her lack of history of psychosis, her behavior with her friends in the days leading up to the event, and her conduct post the death of the children. So it wasn't as if the court focused only on the statement about I don't need a service. And so my question is, and if this had been a jury trial, we wouldn't have any idea what evidence precisely within the statements made by the experts. We wouldn't know. We don't ask jurors, why don't you tell us why you believed or didn't believe the insanity defense, right? Jurors don't lay out, we believe this person, that person. In this case, we happen to have an opinion by the court, but even in the court's opinion at page A14 and into A15, the court says, look, in coming to these conclusions, we looked at everything, every piece of evidence. We looked at the demeanor, the conduct, the attitude of the witnesses. We looked at, we made credibility determinations of each witness, expert and non-expert. And then the court says, and we looked at every piece of evidence. And if there is any evidence that we don't mention, but that was in the record that would be contradictory, it doesn't mean that we considered it and we rejected it. So your point about Dr. Carvalho, that point went to whether or not she had reported hearing the voice of God when she went from YPI to corrections or to whiting. And your point is that Dr. Carvalho's notes indicate that after she left YPI, she did mention to him and maybe other staff that she was hearing voices. But why shouldn't we look at the panel decision, which is quite lengthy and goes into many pieces of evidence, and say, look, they looked at that and they didn't find it credible? And that's my last question. After you answer that, I will yield back to the chief, who will call on other colleagues. But if you can just answer that question, why isn't it enough that the court said we looked at everything, we assessed everything, including things we may not mention directly?
Yes, thank you, Your Honor. You've certainly raised a lot of points in your question. I want to be sure to address all of them. The first being, and of course I'll defer to the record, but I believe what the trial court focused on was the portion of her letter that says, if I burn for eternity, that not so much as Your Honor pointed out, the I don't deserve a service, and they used that as an indicator of her appreciation for the wrongfulness of her conduct. And it's not that the court didn't have before it the body of evidence that it said explicitly that it considered, but it's that that body of evidence can then not be reconciled with the trial court's ultimate conclusion. And the import of Dr. Cavallo's testimony is not only that Ms. Leroya M had in fact identified hearing the voices of God, but it's also that that doctor concurred with Dr. Amble's ultimate diagnosis that there was actually a psychosis in place, which is directly at odds with the testimony of expert witness Dr. Lewis. So when we have a trial court's decision that's couched so firmly in the language of credibility, there still has to be an assessment, an independent assessment of the evidence that the court is relying on to render that credibility determination. And as I've enumerated in the brief, the factors cited by the court, for example, that Leroya M herself wasn't baptized, there's no indication that those would have somehow affected the calculus presented by the expert witness about whether or not Leroya M met the standard for the affirmative defense. So that's the difficulty with the trial court's decision. No doubt it's thorough. No doubt it has the encompassing language that it reviewed all the evidence that was presented. And in a review of all the evidence, that evidence does not support the findings of fact that were reached by the trial court. That's the danger that we've identified in the case, and that's the danger that this court has recognized when saying if you're going to reject an expert testimony, there has to be a basis in the evidence, a reasonable basis in the evidence to just reject Dr. Amble's testimony. So can a trial court reject an expert's testimony? Of course. Does there need to be a basis in the record to support that rejection? Yes. And when you look at the basis that the trial court identifies, that it cites as these weaknesses in Dr. Amble's report, why didn't Dr. Amble ask Leroya M this? Why didn't he ask her this? As Dr. Amble testified, if he felt those questions were necessary and they would have had an impact on his ability to diagnose Leroya M, he would have asked them or he would have assessed them. If he thought she was malingering, he would have noted that. He would not have gotten on the stand and testified that she suffered from a psychosis such that she was unable to appreciate the wrongfulness of her conduct. And I would say, Your Honor spoke of precedents. What we have from this court is State v. Wilson, where we see there was such a careful differentiation when this legislature chose to adopt not merely knowledge that a person's action was wrong, but an appreciation that the conduct is wrongful. And that's precisely the situation Leroya M finds herself in. And that's what the language contains in her letter speaks of. If I'm wrong, God may punish me. The corollary obviously being, I don't think I'm wrong. I think I'm doing what God intended for me to do. I think I'm acting in the best interest of the children. But if I'm mistaken, I'm prepared to accept those consequences. So even though there might be, as I think this court is referred to as an intellectual recognition that the defendant's actions are not in accordance with the criminal code, there still has to be an appreciation that her conduct was in fact wrongful, and that's entirely absent in this case. And that's confirmed not only by the testimony of Dr. Amble and Dr. Cavallo, who again, and I point again to Dr. Cavallo's testimony because that's the most lengthy and objective period of observation that we have. And Dr. Cavallo also addressed the court's concerns about potential malingering, saying there's no evidence of that. And when we're dealing with mental impairment, we know that the narrator might be a potentially unreliable narrator. And we use corroboration, we use our own observation. And throughout all of that, and through that extended period of observation that Dr. Cavallo had the ability to undertake, Dr. Cavallo still came to the same conclusion as Dr. Amble, that is that Leroya M was suffering from a psychosis. And I also, as I have 1 minute left, but we'll return to in my rebuttal, is being cognizant of the level of the burden of proof or persuasion that Leroya M has in this case, which is a preponderance of the evidence. Tipping of the scales, is it more likely than not that she lacked the capacity to appreciate the wrongfulness of her conduct and to conform her behavior? And based on the record below, no reasonable finder of fact could conclude that Leroya M failed to tip the scales in favor of the affirmative defense. And if there are no further questions, I will continue in my rebuttal.
Thank you, counsel.
Thank you.
Justice Story, did you have a question? Your hand was up earlier.
I'm fine. Well, the counsel has done a good job, and we'll see in rebuttal if there's anything I want to pursue. Thanks.
Thank you very much, sir. Attorney Costello, are you ready to proceed?
Yes, I am, Your Honor. Good morning, and may it please the court, I'm Timothy Costello, Senior Assistant State's Attorney appearing on behalf of the state in this matter. In this case, the parties presented competing experts as to the defendant's claim of a mental disease or defect. The experts came to different opinions. One found that she suffered from a mental disease or defect that would satisfy the legal standard. The state's expert found to the contrary, that she did not suffer from a mental disease or defect, and that whatever mental issues she was suffering from were resultant from her commission of the crime. That is, that they were a reactive psychosis. So the dispute in this case is not whether or not the defendant has at some time presented symptomology consistent with a mental disease or defect. The dispute is to whether or not she had one at the time of the crimes that was causally related to an inability to appreciate the wrongfulness of her conduct or to conform her conduct to the requirements of the law. Because there was conflicting evidence, specifically the expert evidence in this case, a rational trier of fact, and indeed the trial court in this case, could credit the state's expert witness and could find the defendant guilty of the charged murders here. That decision is unassailable under the governing standard of review. Now, I understand there is a clear dispute between the state and the defendant as to exactly what the nature of the claim is. The state's position is that this is a sufficiency of the evidence claim, whether or not there was sufficient evidence to sustain the trial court's guilty verdict. The defendant is claiming something else, that under the civil standard articulated in Wizermirsky versus Syracuse or Builders Service Corp., that she is entitled to some sort of a probing review as to the rejection of the defense in isolation because it was premised on expert testimony. That is not founded in our law, and when I try to trace the law back, I do not find an independent appellate claim that can be sustained or carried on that basis. Where that standard has been applied in the criminal law, particularly in State versus Weathers, it is still within the context of a sufficiency of the evidence claim. I would note that a majority of the case law that the defendant cites in her brief, whether it be Medina, whether it be State versus Campbell, are all sufficiency of the evidence claims. So I am a bit confused on behalf of the state as to the exact nature of the review or the claim that the defendant is putting forth. That is why I must say at the end of the day, all that is left of the defendant and all that this court's role entails is to review the sufficiency of the evidence. That standard of review is well established.
Justice Doria.
And so I'm familiar, obviously, with Weathers, and I know you argued Weathers. So you are tethering your argument to the fact that this is a sufficiency, just elementary sufficiency, like in any case, even though the defendant has the burden, and not so much, or disagree with me with this statement. Are you not saying we shouldn't go with the civil standard because there are reasons to distinguish affirmative criminal defenses from the civil standard?
My position is that the sufficiency standard of review, if this is a sufficiency claim, does not permit that civil standard to be incorporated into it. By and large, they are consistent, except for the one fact that in that civil standard says that there must be some basis in the record to reject an expert's opinion. Now, that is inconsistent with the sufficiency standard of review, which decades of case law have said permit this court to presume that a trier of fact drew credibility determinations consistent with its verdict, including discrediting expert witnesses. It is that language, that's the some basis in the record language, that I believe is inconsistent if this is sufficiency review.
So I mean, I guess to the extent that it practically makes a difference, it's that you would like to be able to go further than maybe the memorandum of decision. We have if there's any basis, just like we would with a jury, any basis to affirm, we could look at those things, even if, let's say, the memorandum of decision was internally inconsistent or, arbitrary in some fashion. Let's say it was, discriminatory or something. That might not be a good example because I think we'd probably all say that that's not appropriate. But so can you respond to that? I mean, are you saying that when somebody elects to go with a three-judge panel and they get a memorandum of decision, we should basically almost ignore that and just comb the record to see if it's supportable, just like a jury verdict?
Yes, consistent with this court's precedent in Perez and other cases, this court's review should be exactly the same, whether or not the defendant has elected a jury or a panel of judges. The defendant should not be entitled to some form of special review just because a trial court sat in judgment as to the ultimate verdict.
But this will be my last question, is it really special review? I mean, if you could craft interrogatories, let's say, on an affirmative defense that teased out, I don't know if you're entitled to this, you can tell me, did you believe this expert? Did you believe the other expert? And, we got irrational or inconsistent responses. We could look at that, right? If in a jury case.
I believe if there were legally inconsistent responses, the court could review that. Factually inconsistent ones might be owing to mistake or even Scrivener's errors. I don't believe the court could probe to that degree.
I see. Yep. Okay.
Justice Acker.
Thank you. Good morning, Mr. Costello. So my question is sort of goes along similar lines as Justice Doria's did. I want to frame it a little bit differently, but I think it gets at the same kind of issues. We, as Justice Kahn pointed out, we have here a very carefully explicated courtside opinion, written opinion, as opposed to a jury verdict. So, as jury verdict, you just can't get behind the screen. Unless there's special interrogatories or something like that. But typically, you just look at the answer. You don't get the reasoning. Here it's weird, right? Because we get the reasoning in great detail, and what's weird about it is just sort of when you do that, you have a tendency to want to really press the reasoning and check it out and make sure it all holds up. Not that it's irrational, but just maybe that it's wrong. You disagree with the reasoning, there's some fundamental error in the reasoning, for example. And I guess the question is, I've looked and I haven't found any cases that specifically analyze, at least in Connecticut, why the standard should be the same in a jury case as in a courtside case. Have you found any cases that really examine that question?
I haven't in particular heard cases that examine that particular question. I looked, though, however, to the purpose of the rule. I think we're talking in the area of Practice Book 64-1, which requires the trial court to draft a memorandum of decision when it sits in judgment of various issues, including rendering a verdict at the conclusion of trial. The construction of that rule, which I apologize the parties I don't believe have briefed, but I did look at that a little bit in State versus Cobb and State versus Breton. Cobb is 251 Con 285 at page 382. State versus Breton is 264 Con 327 beginning at page 451 and also page 393 to 394. The court discussed the import of memorandum of decision, and it sort of cast the requirement to craft a memorandum of decision as, I might say, prophylactic, just to compel a adequate record for review and prevent the parties from having to go back and try to rectify the record or compel the court to do so after the fact. The court, however, read that rule as complementary with the ability to seek rectification and read them together as just defining the ability of the parties to craft an adequate record for review. in, I believe it was State versus Cobb, but maybe also State versus Breton, the memorandum of decision that was crafted in a capital phase verdict was very bare bones. It just, the court had said, I have rejected what the defendant has proffered in favor of mitigating factors, have found in favor of the aggravating factors. And this court found that that wasn't compliant with the rule, and that the court could then review the trial record to determine the basis for the court's verdict. So the fact that we require memoranda of decision, even as to trial court verdicts, I don't think should define the scope of this court's review, because that rule has never been construed that way in the past. This court has always, in its review, taken upon itself to be able to review the entirety of the record and to construe it to support the verdict.
Just one other follow-up question. I hadn't thought of that rule in the context, so that's helpful. But I'm still left with this feeling of when we have the explanation, it's sort of hard to ignore it, I guess is one way to put it, and just say, well, whatever they said, maybe it's sort of silly. I'm not saying that's how I feel. I'm just saying, you could come to that conclusion. Maybe it's wrong, and demonstrably so, sort of not factually wrong, but analytically wrong. It's an unfair critique of Dr. Amble, let's say. That's just not a fair critique of Dr. Amble. Let's say we come away with that. But, there's other stuff in the they still had Lewis's testimony, they still had other stuff. And then we go around that. That's sort of weird, isn't it? That we would overlook an analytical error because there's other grounds in the record that would support, that would provide the evidence. You see what I'm saying? You see what I'm asking about?
I think I understand what you're asking about. But at the same time, I think would be a bit of an ambuscade on the trial court, because in crafting its memoranda of decision, I don't believe trial courts are on notice that the nature of review of their memoranda is going to be that probing in this circumstance, because in the past, as to memoranda reflecting verdict, the court has not engaged in that review. If the rules were to specify that there should be more thoroughness, and that the review on appeal would be limited to the four corners of the memorandum decision, I think courts would respond by drafting them differently or more particularly. So I think there's a question of fairness as to the trial court as well. Speaking to the characterization of a witness being unfair, I'll push back on that word, because I'm not sure how fairness in the circumstances of credibility determinations or weighing of testimony would factor in this court's review. I think that might be somewhat of standard.
Yeah, I didn't mean credibility. I meant that the analysis, but I get your point, and I'll yield at this point. Thank you for answering my question.
Thank you, Justice Eckert. Thank you, counsel. Justice Keller.
Thank you, Chief. Good morning, Attorney Costello. Why would this particular group of criminal trial judges have their factual findings looked at differently than we look at other judges' factual findings? This is not a jury trial, so we don't have to really scour the record. We accept their factual findings. We don't retry the facts, and we have to honor their factual findings absent proof that they are clearly erroneous, which means there is no basis in the record whatsoever for the findings they have made. Why isn't that the proper way to look at this?
I don't think I disagree that the court can review, broadly speaking, findings for clear error. I don't think that is in any way inconsistent with the sufficiency of the evidence standard of review, because if a court...
But it is, because with a jury, when we're looking at sufficiency of evidence, and we have to look at the whole record, it's because, as Justice Kahn pointed out earlier, we don't know what the jury thought. We don't know the basis for, what evidence the jury gave more credence to, what evidence they disbelieved. But in this case, the judges are required to put their findings into a written memorandum of decision. So I think we're limited to the facts as they have found them, and limited to reviewing whether those facts are in any way so clearly erroneous that we don't have a fair verdict.
I would disagree. I think the court, just as one prefatory matter, I think the court would have to overrule its prior case law in Perez, in which it has said that the scope of its review is the same regardless of whether the trier of facts is a jury or a panel of judges. So I think there is at least precedent on this point, which would have to be overruled. At the same time, I would just repeat what I said a second ago. If there is a clearly erroneous ruling in the trial court's findings, I think the court can note that. It's not inconsistent with sufficiency review, because if the finding is clearly erroneous, the record also cannot be construed to reach that finding, even in the light most favorable to sustaining the verdict, because to be clear error, there has to be no basis in the record for it. So I don't think that a clearly erroneous finding would be beyond this court's review, simply because the record cannot be construed that way. So the court could find, clear error. But if there is evidence to support the court's ultimate verdict, the court does have to construe the entirety of the record to support that verdict. The trial court here, in its prefatory language, I think accounted for all of these possibilities by very broadly stating that what it had stated was its verdict, and that it had rejected or credited other testimony, regardless of whether or not it had been specifically mentioned. So that the entirety of the record, regardless of whether expressly stated and found or not, has been considered and credited or discredited by this court. In that regard, this court has provided perhaps an over-thorough memorandum of decision, but that could also guide this court's review. I would just note, there is another question.
Thank you, counsel.
Thank you.
Justice Khan.
Thank you, Chief. Counsel, my question is very brief, and I think maybe part of the issue is, in this case, we do have a very detailed 30-page opinion where the court goes into many of the witnesses' testimonies and the pieces of evidence, and focuses on some of the things that I mentioned earlier in my question to your opponent, including, it appears from the evidence that the court did not agree with Dr. Amble, but agreed with Dr. Lewis's testimony that there was even the degree of mental illness, that there wasn't appeared to be any history of psychosis, and it sounds like the court went through evidence that attacked basically, or addressed basically, the three elements: the existence of the mental illness to begin with, the lack of understanding of the legal or moral wrongfulness of the conduct, and then the inability to control, even if there was understanding of the legal or moral wrongfulness, the mental illness is so severe that there's an inability to control the actions due to the mental illness. So it sounds like in this 30-page opinion, although the court didn't highlight each factor, they highlighted the test but didn't highlight each factor, that the court went through the evidence that it viewed went through each factor. My question to you is, in my experience, most of the time it isn't a 30-page detailed opinion. Most of the time, and certainly when I've sat on 3-judge panels in insanity cases, what the bench did was get together, come up with an opinion, and then read the opinion onto the record and order a transcript of that. And it wouldn't go to this level of detail, it would be much more conclusory. Isn't that typically what happens? So, in some ways, are we putting a greater burden on this panel because it went through the trouble of going through a 30-page detailed opinion, even though it noted that there were other pieces of evidence it considered that may not be covered in its opinion? So are we setting a higher standard because of that?
I think the court would be if it were to try to parse out individual findings rather than construing the entire record that way. And it goes back to an earlier point that I stated. The mere fact that the defendant has elected a trial to the court should not entitle him to a different standard of review on appeal. The United States Supreme Court, in getting at this, has cast the defendant's right to be convicted upon sufficient evidence as being a due process right that is protected by appellate review in the context of where the evidence simply is construed in the light most favorable to sustaining the verdict. It has applied that in Jackson versus Virginia. It has applied that in Duckworth, even where a defense was involved. So I would submit that the standard of review is no different, and this court previously has recognized that in Perez.
Thank you, counsel. I yield back to the chief.
Thank you, Justice Khan. Justice Mullins.
Thank you, Chief. Attorney Costello, I'm just curious about one thing, and I'm not on the Weathers case, and so I'm just trying to probe maybe a little bit. Hopefully, it's not completely covered in that case, but the standard that was applied in that case, did I understand you to say it was the expert testimony to discredit an expert or to find sufficiency of the evidence? You have to have some basis in the record, not just expert testimony. We don't agree with that expert testimony. That wouldn't be enough. You need something else in the record to discredit that. Is that right? Is that the standard that is being asked to be applied here?
Yes, I believe the appellate court panel in Weathers did incorporate the language from Wyszomierski v. Syracusa into its analysis. In Weathers, there were two experts who testified. Both of them, at least in part, supported the defendant's mental disease or defect defense, and the state did not present a competing expert in that case. Nevertheless, the court incorporated the civil language, saying that there must be some basis in the record for rejecting the uncontested expert testimony. It did find that there was some basis in the record based upon, in particular, I believe it was Mr. Weathers' conduct about the time of his arrest, which was not necessarily consistent with him experiencing psychosis. So it did find a basis for rejecting expert testimony. But
I think that's my question here. More particularly is even under that standard here, there's enough evidence to satisfy it. So do we? I'm not sure how it's teed up in Weathers if that's the issue or not. But do we have to necessarily decide that issue in this case, given that even under that standard, there appears to be other evidence to discredit the experts?
I would submit that in this case presents an even stronger record for the state, even under the civil standard, because the some basis in the record standard, I submit, would be satisfied where there are competing experts, because competing experts on both sides present some basis in either direction. A credibility determination in favor of one would, I think by definition, be some basis in the record. So I think the court does not necessarily have to resolve the standard here. It may be more squarely presented in Weathers because there wasn't a competing proof, at least as to the expert testimony.
Okay, that was my question. And I think I do understand your argument is that we should not go that way here and just apply the regular sufficiency standard. I just didn't know if this case teed it up better or Weathers did.
Weathers probably tees it up better. I present the argument here, of course, because the defendant has expressly claimed review under that, and I definitely want to defend the state's position that the defendant isn't entitled to that level of probing review. I would also note that I somewhat strategically have decided to present that argument because in many cases before this court or where the appellate court is concerned, where a defense, affirmative or otherwise, has been presented, the court presents the sufficiency evidence standard of review at the beginning of the opinion, but then does appear in its analysis to engage in some degree of a balancing between the proofs in support of the defense as well as the defendant's guilt. And over time, I have found there's a little bit of an inconsistency between that level of analysis and earlier case law, for example, beginning with State versus Goop, where the rule has held that if the factual predicates for the defendant's claim of the defense can be presumed to be discredited, the defense cannot survive sufficiency review, full stop. So that is just the rule that I'm trying to defend in this case. I think Weathers might be a better case for the rule.
Okay, thank you.
Justice Daria.
And so with the two dueling standards in mind, could you speak maybe briefly to your opponent's main point, I guess, about Dr. Carvalho and the religion aspects of it? Because I guess that was not really teed up or mentioned in the MOD. So your position would be they obviously can reject it as a matter of credibility, but how would we square it with the rest of the MOD?
Well, my position would be that Dr. Lewis's testimony in a sense, was squarely responding to the theory of how the defendant's mental disease or defect manifested in the commissions of the crime here. The defendant had reported to Dr. Amble, as revealed in his report, that she had killed the children in the course of a baptismal procedure that she believed was commanded by God in order to save their souls. The fact that she had maybe mentioned some religious ideations at various times was not necessarily inconsistent with the court's ultimate verdict or Dr. Lewis's position that the defendant's description in collateral evidence were inconsistent with the theory of the defense. Specifically, you have the defendant's sister, you have her daycare provider who testified that in the period right around the time of the crime, she is not demonstrating overt religious ideologies. Now, Dr. Lewis's position, it was that a delusion of the religious sort that would satisfy the legal standard for mental disease or defect would be pervasive and bring itself out in all facets of life when a defendant is about to engage in this type of conduct. So Lewis's position was squarely responsive to the defendant's theory of how the crimes played out as a manifestation of the disease by stating that the fact that she's not saying she's hearing these auditory hallucinations from God and that she's not professing these religious delusions in the days surrounding the apparent murder, is inconsistent with the claimed way that the crimes played out. That is also reinforced by the fact that there's evidence in the record for an alternative motive that comes in, which Dr. Lewis and the trial court could also consider that she was motivated by spite against the men in her life, particularly the father of the children, who she believed had abandoned her, as well as other factors and stressors in her life for committing these crimes. The suicide note also did not reveal the clear command hallucinations that the defendant later claimed to her treatment providers. Instead, there are some religious delusions, but they are the sort that anyone with maybe a religious background or a literary background may make in daily life. So they're not inconsistent with Dr. Lewis's statement that there weren't these professions of religion are not inconsistent with the record to the extent that they were not stated. The record does demonstrate that she wasn't making these overt and pervasive demonstrations as Lewis posited would be necessary to support Amble's conclusion.
Justice Keller?
Thank you, Chief. Attorney Costello, how much of her prior DCF record was in evidence before the three-judge panel?
The prior DCF record was in evidence to the extent that it was summarized in the doctor's reports based upon their interviews and review of the records. So we do know of some of the prior contacts, the removal of the children, the termination of parental rights as to some of the older children, and the past neglect contacts.
All right. She had apparently harmed her older children in the past. Does the record indicate that she'd actually physically harmed other children?
I don't recall an overt statement of physical harm. I believe there were.
Wasn't there a child placed into a toilet or something?
I believe that a child's face may have been dunked in water or something.
All right, so, but at no time during this in these DCF records, did they include psychiatric analysis or evaluations of her? Did the experts have a chance to look at prior evaluations that the juvenile court or prior criminal court might have undertaken?
These past history, the summaries contained in the reports do indicate at least contacts with DCF social workers who had appraised her at the time. And there was some indications of maybe mental illness, but they do not, of course. Well,
I mean, the three-judge panel makes the point that at no time has she ever been diagnosed with psychosis during all of this history, correct? Which includes harming children, correct?
That is correct. She hadn't been diagnosed, I believe, with psychosis, no.
And at one point, Dr. Lewis says that there might have been a psychosis developed after all of the events here took place as a reaction, a sort of traumatic reaction to what she had done, which might explain why Yale and Dr. Carvalho saw some symptoms of psychosis. Is that correct?
That is correct. Dr. Lewis's competing diagnosis was that the defendant was experiencing a reactive psychosis in the period after the murders. And she posited that that could have been caused by the act of having killed her children, and would be consistent with a theory that she had killed the children sort of out of a fit of spite or anger at, say, their father or her ex-boyfriend at that time.
And someone noted malingering. I'm trying to remember who noted the malingering. Some psychological expert or psychological treatment provider noted malingering. Was there much of that in the record?
That was in the record because Dr. Amble was cross-examined by his failure to account by it. That was during the period of her pretrial detention. She was seen at John Dempsey Hospital, and a clinician there thought that she might be malingering as to her symptoms at that time. I know I have less than a minute left, so I would just reiterate the state's argument that this is a sufficiency claim, and this court should review it under that governing standard of review. The defense claim plainly fails there. Even if this court does employ the civil standard, there is some basis in the record because this is a classic case of competing experts. The trial court chose one expert, found that expert credible over the other, and that simply is certainly a basis in the record. My time is up. If there are no further questions, I would ask the court to affirm.
Thank you, Attorney Costello. Seeing none, thank you very much. Attorney Fetterman.
Thank you, Your Honor. I have to respectfully disagree with opposing counsel. I think we do know exactly what the standard of review is in this case, and it's quoted on page 2 of the reply brief. On appeal, the issue before this court is whether the trial court's conclusion that a defendant had failed to prove that he lacked substantial capacity as a result of mental disease or defect is supported by the evidence. We must determine only whether any reasonable trier of fact could have rejected the defendant's affirmative defense of mental disease or defect. And again, on page 8 of the reply brief, the language from Campbell, the reviewing court must determine if the defendant met his burden of establishing that the court's rejection of the affirmative defense of mental disease or defect was not reasonably supported by the evidence. So I'm always willing, if unhappy, to stand corrected, but I don't see any language where we construe evidence in the light most favorable to sustaining the trial court's decision. And nowhere in the state's brief did I note any case law that has applied that sufficiency standard that the state now urges to a review of a decision regarding an affirmative defense. Jackson replies to a justification defense. Oh, I'm so sorry, Your Honor.
That's quite all right, counsel. I was trying to wait to a logical break point, but Justice Mullins has a question. Thank you.
Thank you, Chief. Good afternoon, Attorney Fetterman, or good morning. I am curious about the expert testimony, and I'm just wondering, it seems to be that outside of Weathers' appellate court decision, the standard that you can't discredit a expert unless there's some other basis in the record comes from civil cases. Is that right, or are there other criminal cases besides Weathers where we've applied that?
That verbatim language, I would agree, we only see in the civil context. I mean, of course, the overarching idea that the verdict must be supported by the evidence below, we certainly see applied in criminal context. But I believe the specific language that you're asking about is from civil cases.
Let me just ask you, maybe in the civil context where that sort of standard comes from or that rule comes from, what's the underlying reason? I mean, I get the words, but what's the underlying reason to do that? If an expert can be evaluated like any other witness by the fact finder, and if the expert's testimony is internally inconsistent, even if there's nothing else, you could not credit the expert. What is the underlying basis for that requirement? Where's it come from? What's the reasoning behind it? I'm just curious if you know.
I can't point at anything other than what I interpret as a very normalized method and mechanism for this court to be able to have review over the trial court's decision. Just like I answered Justice Kahn's question, if this would have gone to a jury, the defendant would have an opportunity to then file a motion for a judgment notwithstanding the verdict, and we'd have that level of review by a court to make sure that the jury's verdict is actually in accord with the evidence that's presented. And there's nothing radical about the fact that the evidence must support the verdict, right? Of course,
I don't mean to cut you off, but I don't disagree with any of that. I don't think. I'm just wondering why singling out an expert and saying, well, looking at all the evidence, if you have an expert on one side and you don't believe that expert, you can't do that unless you have some other basis in the record. Why single out an expert versus any other witness? I'm just curious if there's a reason. Maybe there is, and I just don't know it. So I'm curious.
Well, I think it's a natural continuation of why we allow the presentation of expert testimony to aid the trier of fact. And we even have Judge Vitale and Judge Blue commenting, we're not doctors, right? We're judges. So we present the expert to aid the trier of fact because we don't expect the trier of fact to have the base of knowledge that he or she would need to make the ultimate determination that's required. So if you're going to reject the testimony of an expert who has been presented to aid you in reaching a fair verdict, there has to be a basis in the record for that. And that's the danger in this case. Again, what I said, when you couch it in terms of credibility, that makes it sound unassailable. But when you look at the reason that the trial court said, I don't credit Dr. Amble's report because the first time Leroya M said anything about hearing the voice of God, it was 3 years later. But that's not true from the record. We see her immediately or almost immediately after the incident making that report. So if you're going to reject the testimony of an expert whose sole function is to aid the trier of fact, there has to be something in the record that supports it, which I believe leads to Justice Kahn's point about if we didn't have this detailed memorandum of decision and we had just had the jury verdict, would we be able to undertake this sort of review? Of course we would, because I would be standing here saying the record does not support the trial court's conclusion. And for reasons A, B, C, and D, which we see from the record, you, Your Honors, cannot sustain the trial court's conclusion, whether it was rendered in 5 pages, 10 pages, or 30 pages. The record simply isn't there. Am I in a different position because I can point specifically to justifications that the trial court has presented? Yes, but ultimately, am I making the same substantive argument to the court that I would be making had the trial court not said we've considered the entirety of the evidence presenting? Yes, because ultimately this court is asked to review the evidence below and determine if any rational trier of fact could have rejected an affirmative defense whose only requirement is to be met by a preponderance. So to circle back to Justice Mullins, your point about it being in a civil case, well, this is a civil standard. The preponderance of the evidence is a civil standard. So why would we hold a defendant in a criminal case with all the attendant liabilities and liberty deprivations to a different standard than we would expect of an appellant in a civil matter when the review of the evidence is by the same standard, preponderance of the evidence? So why would we treat those circumstances differently? If anything, the civil standard should be a baseline standard and the criminal standard more exacting. And although you're on, oh, I'm sorry.
That's quite all right. Don't worry about it. There are 2 justices who have questions. Justice Kahn, your hand was up, and then I think it went down and then up again. So I'm not sure whether you're next or Justice Doria.
It went down by, I don't know how, and so I saw that and raised it back up, but I would defer to Justice Doria by seniority, and I can go after him. Thank you, Chief.
Thank you, Justice Kahn. Justice Doria.
Oh, okay. Thank you. And I think this should be brief. What do you do with the finding, though, counsel, of spite, which I don't think is entirely dependent on experts. I mean, I suppose there's a lot of circumstantial evidence from the letters and otherwise. I mean, once the court, under your standard, let's say, once the court is persuaded that this was a spiteful act, then it's hard to really get behind, I mean, right, she knows right from wrong. She's doing something, for a different reason than psychoses. And so what do you say to that? I mean, that sort of things go away in some ways once they have a reason that they've credited.
Your Honor, my response would be that there's no reason that those are mutually exclusive, that she could also feel spiteful toward her ex-husband, but was indeed suffering from a psychosis. And certainly Dr. Amble's testimony, Dr. Carvalho's account for the existence in her life of those feelings of animus toward her ex, but yet still the behavior emanates from a place of psychosis. And I believe it's in the Wilson case where the Connecticut Supreme Court talks about, it's not that we're seeking total impairment. We're saying substantial incapacity, not total impairment, not that there necessarily can't be any other motivation other than the psychosis, but indeed the psychosis was such that it rendered her unable to appreciate the wrongfulness of her conduct. So I don't think anyone's arguing, or certainly experts are not arguing, that the spitefulness is non-existent or that that's not part of the calculus that they're using, but they're still ultimately reaching a conclusion that due to her mental impairment, she was unable to appreciate the wrongfulness of her conduct or conform her behavior in accordance with our criminal code. So I don't see those, nor do I think any expert has opined that those would have to be mutually exclusive of each other.
Anything further, Justice Doria? Thank you very much, Justice Khan.
Thank you, Chief. I guess my question gets back to the issue of Dr. Amble. So you're focused on the fact that the panel's decision does not credit or does not acknowledge that Dr. Carvalho at the state mental facility noted in his records that the defendant had indicated she heard the voice of God, and that therefore the criticism of the defense expert noting that this issue is a reason, is not a valid rational reason to reject her opinion. However, doesn't the trial court go beyond that? The trial court says not only, I agree with you, it's not mentioned in the opinion, Carvalho's notes, but the trial court's position was that it credited Dr. Lewis's testimony that when you have a psychosis or believe hallucinations, that they don't just happen after the fact, that there is evidence that it happens before, and that these hallucinations and hearing voices of God in commands would have occurred over a longer period of time, and unlike this case, would not have happened several days. You said it immediately after, but she indicated, the first time she indicated hearing the voices of God, the actual voice of God, was not till after she left YPI. And Dr. Lewis's testimony was that this level of hallucination and psychosis would have been there before, and that there was no prior history of any hallucinations, either by family or medical professionals, and that the prior history was actually one of even attempted suicides being malingering or to get attention by medical professionals. So what are we supposed to do with the fact that the trial court went beyond just, even if we agree with you that Carvalho statement should have been mentioned in the opinion, there were other things about that doctor's testimony and about other points in the record that led the court to believe Dr. Lewis over Dr. Gamble. Isn't that really what happened here?
Did the trial court concur with Dr. Lewis's assessment? Yes, and as we've identified in the brief, the difficulty with that in this case is the same vulnerabilities that the court attributes to Dr. Amble are equally, if not more so, present in Dr. Lewis. So when that's analyzed with a preponderance of the evidence standard, that is ultimately an unreasonable result. If you're going to fault Dr. Amble and say you didn't account for all of these extraneous evidentiary findings, and you didn't account for other medical records, and you didn't speak with enough independent witnesses. Those same infirmities are present in Dr. Lewis's testimony. And when Dr. Lewis speaks generally about delusions or how in her experience, how they present, that is at odds with Dr. Amble, who examined her for a greater length of time, spoke to more independent sources, and Dr. Cavallo, who observed her for the greatest length of time and most objectively, right? Because this observation is at York and not as a defense expert or a state's expert. That's ultimately when this court is examining the reasonableness of the trial court's decision. It's not that Dr. Lewis disagreed with the diagnosis presented by Dr. Amble. It's when the court is making the decision about whether the defendant has satisfied her burden of proof. Its reasons for the rejection are unsustainable because they're equally, if not more so, present in Dr. Lewis, whereas Dr. Amble has satisfied those concerns that the court has had.
Thank you, counsel. I yield back to the chief.
Thank you very much, counsel. Your time is up. If you want to add a grace note to your argument, you may do so.
Just to thank your honor so much for your attention and the questions, and I appreciate the depth that you have all seemed to take and the care that you've taken with this case.
Thank you very much, counsel. With that, we will be in recess until our next case, which is 11 o'clock. Thank you very much.
Thank you, your honor.